So without taking too much of our time, I'd just like to introduce our topic for today. Okay, next of kin versus beneficiaries. I'm sure each of these terminologies um, would not pose a challenge to any one of us. We have heard about next of kin, we have heard about beneficiaries. We know on the surface level what they mean, but we are pitching them against each other. Why? And what we found is we found a lot of misconception in the public about this let's say this transaction, this terminologies basically, and it affects the way people view their assets. It affects the way people's expectations basically on their estate. And what we're doing here is to clarify the differences, okay, so that when you're filling those forms and you see next of kin, you're not confused who do I put. When you see beneficiary, you're not confused who do I put. So this webinar is going to clear up that difference between next of kin and beneficiaries, right? And I mean, I beg you not to assume you know the differences or understand the differences. Just stay with us all through the webinar, and I trust that you would learn a thing or two from this. So if you are a return, let's say attendee, you would have seen some familiar faces, the beautiful Chisom Wongbo and the handsome Ebolua Tibobo. They'll be anchoring our webinar this morning. They'll be walking us through this topic and, demystifying a lot of assumptions about this topic and giving you the value that you are here for. Okay. So while we get webinars, the slides up, just give us a couple of minutes to get the slides up and ready to present. Okay, let me just make one more announcement. Okay, we have question and answer sessions at the end of the webinar. So please, you see the question and answer session on your app. Just go there, ask questions that you want to ask. You don't have to wait to the end of the webinar to ask questions, okay? You can go ahead and do that as the webinar progresses. And at the end of the webinar, we'll take all those questions. We're going to be doing something quite unique in this webinar. I understand that some of us might have experiences when it comes to next of kin or beneficiary issues, or some experience with trying to access a deceased loved one's, let's say, assets or properties. I'd just like that we share, what we encountered, if you encountered any difficulty. I mean, if there are as much as you can share, basically, that opportunity will also be available to us in this session. Okay. Ebun, are you ready for us? Awesome. So I'll be handing over to my colleague Ebon to commence the presentation, basically. Ebon, over to you. Please take it away.
All right. Thank you very much, Damilare. Apparently, there was a network glitch earlier on. But great introduction. Thank you for that introduction. Like Damilare has said, throughout the year, we've been talking about estate planning. We've been talking about, different tools in estate planning. We've been talking about, how you can structure your estate, right? But, an intricate part of estate planning that, people tend to not focus on, probably because of the possibility of they think, okay, maybe it's not relevant, or they are probably misconstrued as to how they should go about it, is the concept of next of kin and beneficiaries, right? Over the years, we've come to understand that, most people do not really appreciate or do not really understand the actual meaning of, next of kin and a beneficiary. Right. So we'll be going to the definition of terms of next kin of beneficiary, the legal implications, rights and responsibilities. Obviously, we'll be considering the important considerations, and obviously we'll also just do a brief refresher on estate planning. Right. So why are we saying, or why are we bringing this particular topic to you today? Why are we saying, you need to understand the difference between, having a next of kin or having a beneficiary? It's because in the world of estate planning, you are going to be coming across these two terms regularly, and it's very important and quite imperative, that you understand what we are trying to, or what these terms mean. If you look at the picture currently showing on the screen that's currently been shared, right? So this was a tweet by a popular Twitter user who also happens to be an estate planning advocate. And, in his tweet, it says, so many Nigerians think that their next of kin is the automatic heir to their account. But the truth is that if your next of kin is not to your account, and you don't have a written will, which is most important, to determine that person's legitimacy, the person would not have access to that money at all. Your bank will have to go through a process called a legal probate. This probate period helps them determine who gets the money in your account. This is a very lengthy and expensive process. Even after the whole process is done, your family will have to forfeit some very reasonable amount of the money for legal fees. So this right up here is going to be, a guide throughout the presentation that is going to be going on today. Because as you can see from this tweet, this person has clearly made it, known that a next of kin, contrary to the popular beliefs that most people have, is just a contact person. So most of us, wherever we are probably trying to open a bank account, open an investment, and then they ask us for a next of kin, we automatically just put the person that we expect to inherit this asset or to inherit this portfolio as our next of kin, thinking that that gives them the legal right to actually be entitled to this asset. But unfortunately, that is not the case legally. In next of kin, as you'll be seeing throughout the rest of the presentation, is basically just a contact person. Most times, in the case of emergency or urgent or in other urgent matters, if you are going to be very particular about wanting somebody to benefit from your estate or to have good benefit from your asset, you need to specifically state the person as a beneficiary, and I'll be talking about this also in like my other slides, right? So trying to define terms, trying to actually explain further what is a next of kin and what is a beneficiary. A next of kin, like I subtly mentioned earlier, is basically a contact person. And the irony of it, contrary to also popular belief, is that it doesn't even necessarily include your immediate family members, right? So you have a very good intention to want your brother, your sister, your mother, your father to, sort of like enjoy part of what you've worked for. And then you're like, okay, if I open this investment account, if I open this bank account, and I name these persons that I want them to enjoy benefits of whatever is in these portfolios or in this asset class, and I'm naming them as a next of kin. Unfortunately, that would not fly because, as you see here, a next of kin, it's basically your contact person in terms of emergency situations or in urgent matters. And like I said earlier, to even go for that, it doesn't even need to be a family member. So even the notion that, oh, your next of kin must be somebody directly related to you, it's not really necessary. It's not compulsory that that is the case, right? So what then is a beneficiary if my next of kin cannot directly benefit from my asset? Right. So a beneficiary on the other hand, is somebody that specifically there is an intention, there is um, uh, there's an atmosphere, there is an intention for you to, want that person to benefit from your asset. So you need to be specific. You need to directly say, okay, I want this person to benefit from my asset. How can I do about that? You need to have a will, you need to have a trust where you are naming these persons as the beneficiaries of the asset. So unlike a next of kin where you basically just, input the person's detail, name or what have you as, your contact person. For a beneficiary is much more deeper than that. You need to have certain documentations in place to show that yes, I indeed want this person to benefit from my estate. I indeed want this person to, have access to whatever I've worked for or whatever I've acquired. And there are so many tools by which you can use to do this. And that's why if you've been following our past webinars, we've been talking about the tools in estate planning. About wills, trust, even life insurance is a tool. So all of these are means by which you can specifically name your beneficiaries. There are no ambiguity. There are no second guessing that, oh, did this person actually want it? Because they are documented, they are written, they are legally binding. So by having all of these estate planning tools, you are able to specifically say, yes, indeed, I want this person to be my beneficiary. Yes, indeed, I want this person to benefit from my asset, right? So, if to further dive in, right? I would like to play a very short skit, in as much as we are going to appreciate the humor in it. Just to benefit from this video. So I'd appreciate if you can increase the volume of your devices, either your computer or your phone, depending on wherever you're logging on from, and then just briefly watch the
this morning, before he died. Send me go back. Send me go back to collect. Oh, never go school. Okay, now when they pay loan and the first when they inherit money. You know, it's my job. I don't tell you everything. I don't come and not pay.
Okay, all right. Great one. For the one. So apparently there is this individual. He has a friend, Mazin Duka, who happens to be late, and Mazin Duka named him as the next of kin to his bank account. But unfortunately for the individual left behind as a next of kin, he met the bank manager, and the bank manager told him that, unfortunately, Mazi Nduka doesn't have any money. In fact, he's even owing us. And then he obligated to pay. He've been able to get some humor from the video. Actually, that is not what exists legally in the actual world. Well, it's a skit, so it's people to be well educated and for people to understand exactly what we're talking about, right? So a next of kin, in as much as the person cannot also be entitled to your assets, that person is also not entitled to pay off whatever debts or liabilities that you have. So regardless of whether Mazin Duka has named him as next of kin or not, that person in the video that I just played right now has no obligation to pay whatever debt that Mazin Duka left behind, right? So it's very important that we've been following ourselves, and then we've been able to sort of, like, even at the first instance, understand what we mean by this concept of having a next of kin and having a beneficiary. A next of kin, as a refresher, is basically just a contact person. A beneficiary is somebody who you actually intend to benefit from your assets, right? So the differences between both, as I've certainly mentioned it, but as a beneficiary, right, your role, all you just need to do is to be listed by somebody that says, okay, you know what, I want you to, benefit from my estate. I want you to enjoy something. So you're my beneficiary. All you just need to do is just basically chill, sit down, relax, what is yours, because that person has made their intentions known. That person has put in particular documentations in place and particular tools in place to ensure that you get those assets that the person has bequeathed to you, right? And also, as a beneficiary, in the case of the will, once probate is granted, automatically whatever is yours becomes yours. Right? Once the executors approach the court with the will, and then the court grants the probate, and then the person said, you know what, I want Lagbaja to get A and C. Lagbaja will definitely get it A, B, and C once probate has been granted. Right. But in the case of the next of kin, you know, like I said earlier, a next of kin is basically a person who, will be contacted in cases of emergency or urgent matters. Should somebody be on, deathbed, and then there is a very strong decision as to whether to pull the plug, assuming the person is on a vegetative state, right? And then there are decisions whereby, the person has to pull the plug. In most cases, the next of kin will be contacted in such instance to be able to facilitate that, right? And like I said earlier, the next of kin, the law does not, see the next of kin to be somebody that you intend to benefit your assets. For the law to recognize somebody as the person that would benefit from your assets, you need to specifically state that individual as a beneficiary. You need to specifically say, okay, I want this person to be my beneficiary. So these are like the major differences between these two. And it's quite imperative that we understand and we grasp this fact. I'm sure that many of us here that before now, right, that, I've listed Mr. A as my next of kin for this account. I've listed Mrs. B as my next of kin for this account. And then we're expecting these people to get, whatever is in this account should anything happen to us. But unfortunately, contrary to the popular opinion and the popular misconception, that is not what is practicable. You need to actually have an estate plan. You need to actually have a documented procedure to actually show that you want such persons to be your next of kin. So I was talking earlier about, the law recognizing a beneficiary as the person that, is entitled to your assets, whilst the next of kin simply remains as the next of kin. So how has the law been able to recognize this? How has the law been able to actually let people also understand that, ignorance of the law is not an excuse? You need to be well abreast of the fact that, you need to well abreast of the fact that, your next of kin is basically a contact person, and your beneficiary is somebody that you want to actually benefit from your assets. So if we look at the case of Joseph Fadjemilehin and others, right, is a 2012 decided case, right? In this case, it was actually said that, your next of kin doesn't even necessarily refer to your blood relatives. So if you are of the intention that you want your blood relatives to benefit from your assets, or you want your next of kin to benefit from your assets, it's the best that you better have a structure where those people can be beneficiaries of your asset and then benefit from your assets. Because even in law, the law does not really recognize a next of kin, right, as an automatic beneficiary of your asset, right? So also in that case, it was also said that there's a widespread misconception that if one dies, the fellow's next of kin inherits all of the asset, but that is not so under the Nigerian legal system. And this case is trite. This case, there is no ambiguity as to the decisions in this case, right? Where it was clearly said that, contrary to the popular misconception of the next of kin being automatically accessible to your to your assets, rather, it is not under the Nigerian legal system, right? So going forward, also legally, Section 7.1 of the Administration of Estate Act, which would also say replicated in other administration of estate laws around the states, it also posits that where a person, irrespective of the presence of the next of kin, the person would need to undergo letters of administration, right? So I've mentioned, I was talking about the will earlier, where you can easily state a beneficiary. But what happens when the person now dies without a will? That is where the person would need to sort of like obtain letters of administration, and even the law does not recognize a next of kin as automatically being entitled to a person's assets, regardless of whether or not the person was involved legal in the letter of administration process, right? As far as you're next of kin, you do not have that legal right. You do not have that legal mandate to say that, okay, I'm entitled to this asset. The entire process involved in the letter of administration process, the entire process involved in actually getting the beneficiaries to inherit the asset will have to be followed through. And irrespective of the fact of whether or not you're a next of kin, that would not be feasible in this case, right? So we've seen the differences in the terms of next of kin and beneficiaries. We've understood, basically what it means to have a next of kin and what it means to have a beneficiary, and even the legal implications, right? So, how can we then legally, have a beneficiary? How can we then legally say, okay, we want a beneficiary, we want this particular person to be our beneficiary, and we want this person to inherit our asset or inherit our estate, right? So you can do that via a will, right? Via a will, you can basically name the person as a beneficiary. You can basically say, I want my land at Ikoyi to go to this person. I want my land in Abuja to go to this person. I want my bank accounts to go to this person. You can be sure that once you do that, upon the demise of the person who drafted the will, such assets will go to the intended beneficiaries. You can also do it via a trust. You can open a trust, obviously with that trustees. You can approach us and say, you know what, I want to open a trust and I want certain persons to be the beneficiaries of this trust. I want to open it because I've come to understand that just having a next of kin is not enough for that person to be entitled to your estate. It's not enough for that person to be entitled to what I own. So I actually want to have a trust. I actually want to open a trust so that this person can benefit. And also, like I said in my previous slide, via letters of administration, this occurs where, most it's pleasant, but mostly in the case of a will, right, where the family would then have to approach the court. And like I said, and like I showed us in the first two slides, where that young man in the street, basically and costly that process is. So a letter of administration, in as much as it's also a way by which a beneficiary can access your asset, is not the most preferred, because why not just have a will? Why not just do a will and not let your and costly process of actually obtaining a letter of administration. So with all of this, I really hope that we've been able to, at least in the first instance, grab a very good understanding of what a next of kin is. Actually disparity between these subjects. So on this note, I'll be handing over to the host, Damilare, who will then be ushering us into the other parts of the talk. Thank you very much.
Thank you so much, Evan. I wish I could scream and give all the applause. I'm sure the audience feel the same way. Thank you so much for that beautiful distinction you've painted. I feel like with this, you should not have any, let's say, misunderstanding when it comes to the rights on, when it comes to next of kin and beneficiaries. Again, I'd just like to remind you that the question and answer section is available for the question and answer, let's say, feature is available for your use. You have questions on what we've been discussing, please share them and then we'll respond to them at the end of the webinar. And remember also that I explained that if you have experiences you'd like to share when it comes to perhaps letter of administrations or trying to get a deceased loved one's assets and encountered some challenges, I mean, we would like to hear your story if you're willing to share. So thank you so much. Right now, I'm going to be handing over to my colleague, Chisom, to take the next section of this webinar. Chisom, over to you.
Thank you very much, Dami, and thank you so much, Ebo, and our listeners for sticking with us. Thank you once again. At this point, I would just like to further buttress the points that has already been discussed so far by my colleague, in terms of understanding what the next of kin is, as well as what the beneficiary is. And as I hope that we all have that at the back of our mind, that these are two different roles. And because of that, it's very important to know the rights and responsibilities of each of them. So if we know now that the next of kin is really and truly a close relative that can be called upon in terms of emergencies and all of that, and we now know that a beneficiary is someone who gets benefits, so to speak, from the estate of an individual. So if we know that now, it's now time for us to understand what are the rights and the responsibilities of these persons. Okay, so at first, let's speak on the rights of the beneficiary. We've discussed more, we've talked about how you can make sure that a beneficiary enjoys the benefits of one's estate. And the only way is through a will or a trust or an insurance policy. So that person has to be named, right? So if it's your intention for your next of kin, for example, to benefit from maybe the accounts that you're filling or the pension form or whatever policy that you're filling in that person's name, it is important that you take a next step by creating a legal document, a will and a trust, an insurance policy, or a power of attorney to give legality to that person enjoying that asset. Okay, so these people could be close loved ones, could be a charitable organization, it could even be an endowment, you see. And another thing that you need to note is that a beneficiary cannot have healthcare authority except that you've given that authority through a healthcare power of attorney. Okay, that's how they can make decisions regarding your health. So it's one thing to say, okay, I'm filling a form and my next of kin, maybe for example, it's a life or a health insurance policy you're filling up, and you want your wife to be to make those decisions. You filling that person as your next of kin on that policy is not enough. You have to create what is called a power of attorney or a healthcare power of attorney to give your wife that legal power to make those decisions in your stead. Okay. And then unlike next of kin, beneficiaries, they don't have any legal obligations to settle any debts or whatever. All they do is enjoy the benefits from the trust, so for example, or from the will. You see? So it's very, very important to have that understanding at the back of our minds. And from understanding the rights, you can see where these individuals that you currently know who should benefit from your estate, so to speak. So that's very key to know. So now when we talk about the rights and responsibilities of a next of kin, we've talked about how they are more like an emergency contact, and they're the people who, in most cases, will notify your loved ones, right? And you're on some important contacts like your bank, because that is more, in most sense the most popular time where people have to fill that particular portion that says who is my next of kin. So that person will be responsible for contacting your loved ones and important contacts to say, oh, something has happened. What is the next step that we can take? And also they identify assets. So in terms of administration of your estate, these individuals, especially if you've chosen right, we'll get to that. This individual will be the one to identify your assets. And in some cases, will ultimately have to apply for, a grant of probate, or even go through the lengthy process of getting letters of administration. And like we saw in the video, if you leave any debts, it will be the individual to, in most cases, settle the debt. Now, the question is, how do they settle that debt? They settle it through your estate. Obviously, an individual who you've named as your next of kin will not settle the debt from their own funds. They would have to settle it from the estate. Now, the question is, how would they do that? Considering that in this scenario, the person is late or deceased, So how do they do that? So if you don't have the right step done, if you don't have the structure in place, for example, if you don't have a will to say, this is what can happen, this is how you can access this, or you have a trust to say, call the trustees, like AfriInvest trustees, so that they can provide certain funds or emergency funds so to be able to pay some of these debts and handle hospital bills, burial arrangements, and even filing estate taxes. So it's important to know that whereas in most cases, the intention is that the next of kin might benefit. In some case, you have to think thoroughly who amongst your loved ones can play this role. Because you want your wife to benefit, does not necessarily mean that she'll be able to do this running around when the time comes. So it's important you think about who is your next of kin and also if they will be beneficiaries or not. Okay, so let's go to important considerations. So at this point, we're going to be discussing things, very important points to consider in terms of when you're thinking about, estate distribution, managing your estate, or even planning your estate. We've delved into understanding what the next of kin is and what the beneficiary is and how it can be interchanged. Because in most cases, I mean, if you ask questions, a lot of people will say, oh, my next of kin is my beneficiary. But really and truly it's not. And we've looked at the legal precedents, we've looked at a lot of things to show us that can be used interchangeably, but it's not the same role. Okay, so and it's important that when you're thinking about planning your estate, you create ways that makes things seamless and easy. And really and truly, the only way to do that is to have professionals to guide you, like AfriInvest trustees. Very, very important to have that. Okay, so that they can sit with you and ask this, tough questions. Because you want your wife to benefit doesn't mean she can be the next of kin. You have to think about how to pass on the next generation as easy and as seamless as possible. Okay, by this way, you're able to give meaningful gifts, you're able to preserve long-term memories, and your companies or your goals for yourself last even to the fifth, to the sixth, seventh generation going and going. That's the whole idea of estate planning. Okay, so the other things we need to discuss is legal considerations. We've seen the legal precedents that in most cases, the law is very, very clear on who the next of kin is, and that the next of kin would not necessarily benefit from your estate. Okay, and it's also important to know that the certain dynamics of life that change makes it very, very it's the certain dynamics of life that change makes it important that you have these situations thought about and and provided for to be able to have all of these issues not become more than it should be at the end of the day. And like I said, very important to consult professionals like ourselves to advise you and hold your hand when making these decisions. We have a case of a person, of a woman. She lost her husband, you see, and she was using his debit card, and she continued to use it. I mean, she had pain until that card expired. And she went into the bank, and they said, "Madam, this is not your account. This is your husband. Where's your husband?" And she said, "My husband is late, but I mean, I have his PIN." And they said, "No, madam, you have to bring letters of administration or grant of probate if your husband had a will." And she was taken aback and like, "But this is my husband. I'm his next of kin." And she was left feeling sad and disappointed. Obviously, luckily for her, she spoke to us, and obviously we guided her on the next steps. But some situations could even be worse than this, with people who have no clue and start to complain. And in most cases, some people even forget that they have this accounts in the bank sitting down just because they expect that the next of they're supposed to just continue to receive those funds without knowing and doing the right process. And another very important thing to consider is when deciding who your next of kin is, it's not necessarily that the person who is your next of kin has to be your loved one. It could be a friend. It has to be somebody that you know that can rise to the occasion, that can do the running around, speaking to the right people, to get the right information and get things done. So we're not just saying, oh, this has to be my loved one. You can start to think about it now. It could be your it could be your friend, it could be somebody who you know that at any time you can call that person. That's the person that is advisable to be named as a next of kin. Okay, so and communication is key. You can have these conversations with this person and let them know this is what my intentions are. And obviously taking the next step of putting a legal structure in place by speaking to us, Afri-Invest trustees, to guide you and creating the structure and make things easier in the long run. Okay, estate planning. Let's speak on estate planning. Estate planning is the key, is the key to open this door. Is the key to creating a life of ease and peace and seamlessness. Okay. Now, there's no one way for one person. I mean, there's a lot of options available for different people at different points of their lives. Okay, so and clear communication cannot be overstated when you're creating your estate plan documents. It's very clear. Okay, it has to be clear, concise to avoid ambiguity. We spoke about this in our last webinar when we were discussing who is supposed to benefit from a will. Is it my wife or is it my children? Very clear. If everything is clear, there'll be no cause for this is what this person thought of. If everything is clear and it will avoid issues at the end. And these issues also leads to family harmony. When there are no issues in terms of distribution of assets of maybe a matron or a patron of the family continues to go, and that's where you hear of stories of the big families, obviously in the Western countries that have been in existence for years and years of years. Okay, so that's how they do this, by creating an estate plan that stands the test of time. And we've talked about special considerations. I mean, we've heard of cases of people providing for the lifetime of their pets, for a cat, for a dog. Those are, I mean, that can be done. Who's to say you can't do that? Okay, what about charitable needs or charitable intentions that you have? There is no other easier way to do that than to either do that through a trust or a will. So estate planning and proper communication is very, very important. Now, documentation, we've talked about it, okay? Now, in this point, we have to reflect on the dynamics of life. Marriages, births, deaths, it's inevitable that it will happen, okay? So your documentation has to be in line with this and foresee certain contingencies. That's the idea of having an estate plan, is to look into the future, look into what you want, and be able to create and provide feedbacks. What's the word? To provide like a cushion, right, for some of these issues. So adapting to legal changes, very key. That's why having a professional like Afri-Invest trustees is important, because always updating and regularly updating your estate plan documentation would help in the long run to also comply with the new legal standards, and also apply with the new trends, legal trends, to provide and protect your beneficiaries as well as your assets. Okay, we've talked about special considerations, so it is also important to include them in documentations. So to provide for all of those things that you want, even individuals that are not necessarily keen, your estate plan can provide for them and continue to do that without any interference from anyone. So at this point, I just want to say a big thank you for sticking with us, and I'm going to hand over to Dami to take on the questions and answer. Thank you so much.
Thank you so much, Chisom. Thank you so much for giving us that clarity, basically, and showing us how to go about setting up this estate plan. Okay, so okay, I see that the audience are giving you a shout out also. So without further ado, let's go into the question and answer section. I'd mentioned that if you had questions or you had stories to share about this whole thing around next of kin and beneficiaries, I think we are able to accommodate one or two people to share if we have that. Anybody, somebody, you have a story to share. If you notice, we brought out a lot of live scenarios. Okay, I see Akpan Aniakan raising his hand. Um, Akpan, you should be able to speak any moment from now. Okay, just unmute your. Okay, awesome.
Good afternoon.
Good afternoon, sir.
I I am very grateful for the highlights you gave to us in respect of the next of king and the beneficiary. At least you have told more lights to it. Because
Yeah,
most of the time, I think the next of king is automatically the beneficiary. Thanks for your information given to us. But this thing that
awesome.
bank just introduced, I don't know if it would, it has a legal implication. A friend of mine said there's this form in bank, payments
Mhm.
on debt, that if we want to open a bank account, there's a form called payment on debt. If peradventure the person's late, that they can pay the cash instantly. What is the legal implication of that?
Okay, thank you so much for that question. Chisom Ebun, do you have any um, response to Mr. Akman's question?
Yeah. So, if I get Mr. Akpan correctly, so he's saying that the bank have some sort of form that if the owner of if the person that filled that form
The
is
account
no,
holder, yeah, yeah,
yes, the persons listed in the form can benefit, right?
yeah.
Yeah, okay. So, whilst I'm not very familiar with that practice, in fact, I don't know if it is legally possible or if the law allows for it. I may understand, where that notion is coming from, because in as much as you require an estate plan for your beneficiary to have access to certain part of your assets, for example, despite the fact that the Pension Reform Act, Clause 8B, says that, without a will or a letter of administration, your beneficiary cannot access your pension. Some companies have been able to, which you'll find mostly in the oil and gas space, they've been able to have what they call closed unit pensions, right? So what they do is that in between the organization itself, outside of having a pension house itself, there are certain benefits that they do for their staffs, right? So it may be possible, being that that is a separate arrangement. That is a separate arrangement which was done at the lifetime of the person before the person died, right? So if you were following what I was explaining during my webinar, I said intention is very important. It's very, very important for you to show clear intention of who you want a beneficiary to be. It's very important for you to show clear intention of what you want a beneficiary to have access to. So if the banking system has been able to sort of like should I say put a backdoor to it, which as I said, I'm not quite familiar of now. I may see that being possible, right? But if after the person's demise, nothing of distant, and the person apparently passed on without a will, unfortunately, they would have to go through the lengthy process of obtaining a letter of administration to access such balances in the account. I hope that answers the
Thank you so
question.
much, Evan. Thank you so much, Evan. I think that does. And I mean, like you said, I think you said it's a recent development, and it's something we're going to look into to see where it stands, legally and how that comes to play in our industry. Okay, I have Henry Ekenokot also raising his hand. You should be able to speak any moment from now. Hello, Mr. Henry, can you hear us? You can unmute your mic. You should be able to speak now. Hello, Mr. Henry. Okay. Okay, let's take someone else. One, Mr. Henry. I'm not sure. Is there another person interested in sharing experiences on this? Okay, so Mr. Henry, for some reason we can't hear you. I think you have to unmute your mic. So let's go on. In the meantime, let's go on to answer some of the questions that have been asked. Okay, so this first question says, please, can the next of kin be the named beneficiary? If yes, how does this work? Ebu, can I throw this to you?
Yeah, sure. Yes. Good question, actually. Good question. Yes and yes and yes. 3 yeses. Your next of kin can also be a beneficiary. Even currently, most of us have our next of kin as our beneficiaries, but we do not know. Now, how have we done, right? So let's say, for example, you opened an investment account or a bank account, and you've already listed a loved one, your sibling, your relative as your next of kin. And obviously, you have a clear intention to also let that person be a beneficiary. And then you already have a will or a trust for which the person that you had previously listed in an account as your next of kin is now also appearing in your will or your trust as a beneficiary. By that means alone, you've been able to, make that person your next of kin and make that person a beneficiary. So nothing precludes you from having the same person act as your next of kin and also benefit from your assets as a beneficiary.
Okay, brilliant. Thank you so much for answering that. Okay, so Chisom, let me throw this to you. This question is asking, my question is there any reason that may make the bank or insurance company not to honor the will or the contents of the will during?
Okay. So the bank or the insurance company cannot honor a will because they are not the probate registry. Okay. What the bank will ask for is letters of administration or grant of probate. So that's if the person dies without a will, the person has to get grant of probate, right? But then the person dies with a will, the person has to get letters of administration. Okay. So that's what the bank will ask for. And I also want to use this opportunity to talk about the POD form that I think Aliyu mentioned. I hope I got his name correctly. Yeah, there have been talks about the banks bringing out that form and using it. But however, the legality of that form is still in question. Okay, not a lot of the banks would even accept that. Insurance companies can say, okay, they will pay to the named beneficiary, okay, at the end of the policy or if the policyholder dies. But if another person comes in to say, oh, I should benefit from this policy, they would ask you to go and bring grant of probate or letters of administration. So it's always important to speak to professionals, and really and truly getting grant of probate or getting letters of administration, while that process can be cumbersome, if you have a professional guiding you, makes it a little bit more seamless. Or you go the route of a trust. Having a trust takes all of these, issues and solves it in the first instance. So I hope I've been able to answer that question.
Yeah, thank you so much, Chisom. I think that answers that question. Okay, so there's another question about how do I open a trust? Chisom, can I throw that to you too?
Yeah, absolutely. I mean, opening a trust is as simple as ABC, like speaking to AfriInvest trustees, okay?
Absolutely.
Opening the trust, we have a conversation with you, understanding your needs and preferred solutions. we have different types of trust that would suit different people at whatever stage of life that they are in. So after this webinar, please feel free to reach us. One sec, or the numbers on your screen, and we are very happy to take that conversation and close off successfully. Thank you.
Awesome, thank you. I think this might be a good time to point out one of our products, private investment trust. So when you say we can cater to everyone across every income stream or income category, we do have a product called private investment trust services. It's I know when you hear of trust, you think, oh, you have to be a billionaire before you can do that, but no. We have, like I said, we have products that suits every one within the economic spectrum. Okay, Evan, let me throw this last question to you before we wrap up. So what is the place of power of attorney in sharing of assets as against the next of kin? So it's asked by an anonymous attendee.
Okay, so the place of the power of attorney in the sharing of assets, right? A power of attorney is valid, right? A power of attorney is okay. I mean, you could have a medical power of attorney, you could have a financial power of attorney, right? So it then depends on the kind of power of attorney that the donor granted the donee, and then the extent of the rights that the donor granted the donee to do, right? So if you have a power of attorney, it to an extent, yeah, it allows the donee, that is whoever you donated that power to over your financial assets, to make certain financial decisions on your behalf, right? But it automatically does not make you the beneficiary of those assets, right? So having a power of attorney simply means having the power to do certain things that the person gave you power to do in that power of attorney document. In that document, consummating your relationship between the person that granted you that power, right? And that is why we said it's always too good to have either a will or a trust, right? Because with a will or a trust, you are specifically saying, okay, this is the person that's this. But with a power of attorney, you are basically giving somebody the power to make certain decisions as regarding your financial assets, right? So it doesn't necessarily make you a beneficiary. It may grant you the power to do certain things as regarding the person's asset. But that's all that there is to it as regards the power of attorney in that respect.
Okay, thank you so much, everyone. So there's this one more question from our audience. I think I'll just take this. Is asking, so following the question on the bank's POD, is it possible that there's a collaboration between banks and the trustees in this regard? Yes, this is possible, but again, we do not have any information to verify this. So perhaps it's something we can take in the the emails we send to our audiences on responses to some of these questions and answers that I've received here. But off the top of our head, we do not know of any collaboration between the banks and the trust industry in this regard. So okay, someone is sharing. What's the difference between the next of kin and beneficiary? Okay, I remember when I lost my dad, the bank didn't call me up as the next of kin until I stumbled on a document signifying that I'm the next of kin. That's how I followed it up. Okay, so sorry, Mr. Henry, we would not be able to go over these differences again. But what we can do is this meeting is being recorded, and these slides will be shared with you since you registered for the webinar. So after the webinar, our team is going to send across the recorded session, the responses to questions asked, and the slides presented, so you can go over them to get the answers that you seek. This would bring us to the end of this webinar. I want to expressly say thank you to everyone who has joined. For those who have been with us from the beginning, OGs before IG, say a very big thank you for sticking with us. We do not take your loyalty for granted. So this brings us to the last webinar in the year 2023. 2024, we're going to be coming back with interesting topics on trust products and trust services to share with you. And allow me to say Merry Christmas and Happy New Year in advance. Thank you so much for attending. God bless you all. Have a wonderful day.
Thank you, everyone.